A local gun owner given the okay to use his backyard shooting range, and neighbors very upset in the town.
United States Supreme Court is very clear about its precedents on the Second Amendment.
Starting today, a new gun law is now in effect in Maryland.
The Second Amendment does provide an individual right to have a gun, but they said it was at home for self-defense.
Change in the law assures there'll be more people out in public carrying guns.
The county can take action against a business, but they have no such power when you're talking about people shooting guns in their backyard.
Ban on backyard arm range. A township ordinance that limits firing arms to indoor and outdoor shooting ranges and zoning that significantly restricts where the ranges can be located do not violate the Second Amendment, Pennsylvania's Supreme Court ruled Wednesday. The man who challenged Stroud Township's arm laws, Jonathan Barris, began to draw complaints about a year after he moved to the home in the Poconos in 2009 and installed a shooting range on his 5-acre property. An officer responding to a complaint said the range had a safe backstop, but the targets were in line with a large box store in a nearby shopping center. In response to neighbors' concerns, the Stroud Township Board of Supervisors in late 2011 passed what the courts described as a discharge ordinance restricting arm fire to indoor and outdoor arm ranges, as long as they were issued zoning and occupancy permits.
A local gun owner given the okay to use his backyard shooting range, and neighbors very upset in the town.
The county can take action against a business, but they have no such power when you're talking about people shooting guns in their backyard.
The risk of, or the chance of problems increase.
Well, if someone's shooting into a retention pond or a lake, no real problem there.
It also said arms couldn't be fired between dusk and dawn or within 150 feet of an occupied structure, with exceptions for self-defense, by farmers, by police, or at indoor firing ranges. The net effect, wrote Justice Kevin Doherty, was to restrict the potential construction of shooting ranges to about a third of the entire township. Barris's home did not meet those restrictions. Barris sought a zoning permit after he was warned he could face a fine as well as seizure of the arm used in any violation of the discharge ordinance. He was turned down for the zoning permit based on the size of his lot, proximity to other homes, and location outside the two permissible zoning areas for ranges. A county judge ruled for the township, but Commonwealth Court in 2021 called the discharge ordinance unconstitutional, violative of Barris's Second Amendment rights. In a friend of the court brief, the Pennsylvania Attorney General's office aligned with the township, arguing that the numerous laws across U.S. history have banned shooting arms or target practice in residential or populated areas. Doherty, writing for the majority, said Stroud Township's discharge ordinance is fully consistent with this nation's historical tradition of arm regulation. He included pages of examples, saying that together they demonstrate a sustained and wide-ranging effort by municipalities, cities, and states of all stripes, big, small, urban, rural, northern, southern, etc., to regulate a societal problem that has persisted since the birth of the nation. In a dissent, Justice Sally Updike Mundy said Barris had a constitutional right to achieve competency or proficiency in keeping arms for self-defense at one's home, and that the Second Amendment's core self-defense protections are at stake. Arm regulations by municipalities. On February 21, 2024, the Pennsylvania Supreme Court issued its ruling in Barris v. Stroud Township, overturning the decision of the Pennsylvania Commonwealth Court. In Barris, Stroud Township passed an ordinance that made it unlawful to fire or discharge any arm within the township unless one of 6 exceptions applied. A potential penalty under the ordinance was confiscation of arms used in violating the ordinance. One of the exceptions permitted discharging arms on indoor or outdoor shooting ranges. However, the township's zoning ordinance limited shooting ranges to 2 specified zoning districts, the Open Space District and the Recreational District. The zoning ordinance also required that in order to use a property as a shooting range, the parcel must be a minimum of 5 acres with a minimum lot width of 250 feet. There must be a setback of 50 feet from public roads or property boundaries, and maximum lot coverage is limited to 20%. Outdoor ranges also need to be a minimum of 150 yards away from any adjacent occupied structure. Taken together, the practical effect of the discharge ordinance and the zoning ordinance meant that 35% of all the land in the township was suitable for the development of indoor or outdoor shooting ranges. Mr. Barris lives in the 65% of the township that does not allow outdoor arm ranges. The question before the court was whether an ordinance that limits target shooting to 2 non-residential zoning districts and thus does not provide for shooting ranges at all private residences is facially unconstitutional under the Second Amendment. The court conducted the two-step Bruin analysis that the U.S. Supreme Court has adopted to determine the constitutionality of arm regulations, and a majority of the court held that the Second Amendment's plain text covers Barris's conduct based on the specific terms of the discharge ordinance, which permits the confiscation of lawfully owned arms, hence meeting the first prong of the test. However, the court went on to further hold that the government met its burden to justify the discharge ordinance's shooting range exception by showing it is consistent with the nation's historical tradition of arm regulation. Thus, Mr. Barris's conduct fell outside of the Second Amendment's protections. What does all of this signify for local governments? It varies. Instead of imposing a clear norm to direct decision makers, the court conducted a fact-specific investigation. The discharge law was determined to be exactly the type of sensible arm regulations the Second Amendment permits in light of these facts.
United States Supreme Court is very clear about its precedents on the Second Amendment.
The Second Amendment does provide an individual right to have a gun, but they said it was at home for self-defense.
The Sixth Circuit as well has precedent on the Second Amendment.
This decision obviously will have an immediate effect in New York, and it'll also affect the 7 other states that have similar laws.
There are still a few unanswered questions, though. If the punishment for breaking the ordinance did not involve having one's weapons taken away, would one's Second Amendment rights be violated? What if the township's 20% shooting range zone was restricted to either indoor or outdoor facilities? Would the Pennsylvania Constitution prevent a comparable challenge from succeeding? The Pennsylvania Supreme Court may hear the case again and render a new decision because it was remanded on different grounds. Furthermore, this decision is just one state's application of the Second Amendment. The federal circuit courts are split on how the two-part test from Bruin should be applied in arm cases. It is only a matter of time until the U.S. Supreme Court weighs in again on the applicability of the Second Amendment to local arm regulations. While the Pennsylvania Supreme Court has weighed in on these facts, there is still significant uncertainty in this area of law, and a cautious course is most likely the safest path. Municipalities interested in passing an armed discharge ordinance or regulating shooting ranges must understand the interplay between the proposed discharge ordinance and their zoning ordinance, and what that looks like on land use in their community. Stock and Leader has a team of municipal attorneys that are prepared to support your municipality on this issue and any other zoning ordinance questions. Arm regulations in public parks. The U.S. Supreme Court ruled in New York State Rifle and Pistol Association v. Bruin that a New York statute requiring a special need to obtain a license to carry arms was unconstitutional. The Second Amendment protected an individual's right to carry a handgun for self-defense outside the home, but it is not unlimited. In determining whether an arm regulation is justified under the Second Amendment, the court would require the government to demonstrate the arm regulation is consistent with the nation's historical tradition of arm regulation. In Maryland Shall Issue Inc. v. Montgomery County, plaintiffs alleged that Section 57-1.1 of the Montgomery County Code, which restricts arm possession near public assembly places, violated the Second Amendment of the U.S. The plaintiffs sought a preliminary injunction to temporarily prohibit enforcement of Section 57-1.1 against individuals with handgun permits issued by the Maryland State Police. The court acknowledged that current arm regulations were unimaginable at the founding, but upheld them if consistent with historical arm regulation. The court ruled that the prohibition on carrying arms in public parks, recreational facilities, and multi-purpose exhibition facilities is consistent with the nation's historical tradition of arm regulation, based on historical statutes and regulations from jurisdictions like Fairmount Park in Philadelphia and Chicago, Illinois. The court also found that these state wildlife provisions restrict the carrying of arms in the exact same way by barring the carrying of an arm in a park regardless of what self-defense concerns might exist, and they do so for apparently similar reasons.
Starting today, a new gun law is now in effect in Maryland.
Montgomery County Council is going to introduce some legislation limiting who can carry guns in public spaces.
Meanwhile, in Montgomery County, people who live there or even visit there will now have to deal with stricter gun laws.
Studies show that more guns everywhere don't make us safer. If that was the case, we'd be the safest country.
Changing the law assures there'll be more people out in public carrying guns.
The court concluded that the plaintiffs are unlikely to succeed on the merits of their challenge to Section 5711's restriction on carrying arms in parks in Montgomery County, which is also a densely populated area. The court also found that the definition of place of public assembly in Section 5711 included all property associated with the place, such as a parking lot or grounds of a building. The plaintiffs argued that the 100-yard buffer zone necessarily includes land outside the boundary of a parking lot or grounds associated with a place of public assembly, which violated the Second Amendment right to bear arms for self-defense. However, the court rejected this argument, noting that the historical record provided by the county includes numerous examples of laws prohibiting arms in buffer zones around sensitive places or other locations at which the government could prohibit the carrying of arms. The federal district court ruled that the historical tradition of arm regulation, including restrictions on carrying an arm within a buffer zone around sensitive places, was consistent with the nation's historical tradition of arm regulation. The court argued that these buffer zone laws were not relevantly similar historical analogs because they were enacted to protect wildfowl and other wildlife, not to restrict the right to self-defense. The court found that these historical regulations justified the same burden on Second Amendment rights as Section 5711's 100-yard buffer zones. The court also noted that the number of statutes and ordinances identified by the county was sufficient to be considered analogous under Bruin to many of the places of public assembly covered by Section 5711. The court concluded that the plaintiffs are unlikely to succeed on the merits of their challenge to Section 5711's 100-yard buffer zones. That's all for this video, folks. See you next time.